Hello viewers, welcome to our program on immigration and legal affairs. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman, who's probably about to come back from India soon, and we'll get all the news from India from him next program. So with that, we want to start with an important, a very interesting question today. This is a gentleman who came to US on H-1B visa, and the employer was nice. He filed a perm labor certification for him. The labor certification was approved. This happened sometimes in August, remember, of 2007, when all of a sudden they made all the categories current. So at that point, since he had the labor certification approved, he was able to file a I-140 and a 485 adjustment of status concurrently, means together, that was permitted.
Yep.
Simultaneously. And because of that, he was able to get a work permit for him, his wife, both,
Right.
which
And
was a
travel
very,
document.
very lucky thing for many people. After getting that, he get a EAD, both husband and wife, and he decided to leave that employer and start working with a new employer on an EAD. After 180 days, again he shifted officially, he said, to the new employer. In the meantime, he made a travel also. He went to India and came back. Remember, there's an option. He had an option of either using H-1B to come back or a advance parole to come back.
That's right. And maybe we just want to explain to the viewers that there is a memorandum that's out there that gives an individual who's in what's called AOS status, which is an applicant for adjustment of status, that when they come into the United States, they have a choice of either using an H-1B to reenter if they have an H-1B that's valid, or they can come in on their advanced parole travel document, which now is subsumed within the employment authorization document in most cases.
Now, unfortunately, what happens is I-140, which had an RFE before, that's why it took a long time. Finally, Immigration Service denied the I-140 because in his labor certification, actually, he was owning the company himself. He did not disclose that. As a result of which, they said his labor certification was not valid. Now, I-140 was denied, the I-485 is denied, the EAD is no longer valid. He's in a big mess.
Right.
So what kind of, now basically other thing is that he already was in the 7th year of H-1B.
Okay.
Now many problems come out of this, okay?
Yeah.
He can't go back to H-1 from EAD, it's difficult.
Right. Well, he can't because he entered the United States as an applicant for adjustment of status. So what he did is, by operation of law, he converted his status from H-1B to AOS. So when he came in to verify his work authorization with his employer, he does it using that employment authorization document. So technically, he's no longer H-1B. Now, what I probably would have done is, notwithstanding the fact that I would have encountered probably a great deal of resistance from this client, I would have pushed him to do an H-1B with the new employer and not come back in using the employment authorization document or the EAD, the travel document. I probably would have pushed him to use that H-1B to come back in.
Somehow he would have stayed with the same employer for some little more period of time until the I-140 was approved. But this is a big mess here. Now, if he stays beyond, in spite of all the denials, he continues to stay illegally, he's going to incur unlawful presence of maybe 10 years if he ever goes back out of the country. Okay. Also, if he doesn't do that, this option is there that he could go back to India for 1 year and start a new H-1 again, 6 years all over again. But I mean, for some people it's very difficult if they have children going to school, the wife, and it's difficult. But these are the kind of cases where we tell people, before taking any action of this nature,
Do the complete analysis.
complete analysis,
Right.
plan it right. Like you make a house. If you're a good architect, he makes a foundation very perfect. The house is standing by, no problems and good. If you're a bad architect, and the house is like this. It's difficult to just make it straighten.
Well, I make better visas than I make houses. You don't want to live in any house either.
Yeah, okay, I know that.
But actually, looking at this scenario, Michael, I think one of the things that I would have probably looked at very carefully is if I knew that the individual owned the company, I probably would have said, you're going to have a problem with the I-140, and it probably wouldn't have gotten approved. I probably would have had the individual sell the stock to someone, and then they would have been able to continue the case if they sold the stock. And there are two mechanisms that you can use. One is you can sell the stock to anyone who's not an immediate relative, because then that would work for the purposes of making it still a viable case. The other option is to use something called a voting trust agreement, which is a corporate, it's a corporate instrument where what you do is you give away a legal interest in the property, and yet you retain the equitable interest. So that would be another way to do it. So there really would have been two ways that we could have planned this case so the individual didn't find himself in this predicament.
See, another problem is this. Most of the employees that are working on H-1B, they have some idea about the employer. Employer is not paying the wages in time. There are some other complaints going on. Employer is under investigation. At that point, a person should be smart to start another new labor cert, because he knows as long as a labor certification is pending for more than a year, he can still utilize the extension to 7th, 8th, 9th years or whatever. Right. I mean, assuming that he had entered on a H1 and continuing H1, and if this 7th year is gone and there's no labor certification pending for more than a year, that becomes a problem also.
Right, and Michael, you also raise a really good point, which is what we try to ask everyone who's coming to us for consular processing type of advice. We always say to them, tell us about your employer. Tell us if you think your employer is is violating any laws. Have there been any complaints by disgruntled employees against your employer? Because it's possible that that may have trickled back to the consular offices abroad.
So this is a very, very important thing for people to plan things right. And people, those who come on a visitor visa, student visa, change their status to H1, they don't have a stamp, they go to India, the wife goes to India, emergency, father is sick, go to the American consulate applying for either H1 or H4 visa. The American consulate will grill them. And especially if there are problems, the employer, I can tell you that I have seen most of the time, American consul will always go on the website of the company. They want to see all those issues that we were talking in the last program. How many employees they have, what kind of revenue.
So what the locations are where the individuals are working. That's really big now. Because if you didn't include an itinerary saying where your individuals are going to be transferred, then they have the right to call that into question.
I think it's time for a short break. And right after the break, we'll come back and discuss some other interesting issues. So stay tuned. We will be back.
Right back.
Welcome back. Now, it's another interesting subject we want to talk about. Let me start this way. I recently had a client. He came in and he says that I have two wives. I could bring one wife here. She has a green card. But the other wife is sitting back in India or Pakistan. I don't remember, somewhere. So he said, I want to bring him. Please help me to bring my second wife. So jokingly first I said, that in this country it is difficult to have one. You are talking about two, but he said, no, my religion permits that I can have two. I said, no, your religion permits, you can even have four. The point here is that
may make it a little easier then.
I see. So what I explained to him is, this is what I want to tell our viewers, that there are certain things which go by the laws of the country where the event takes place, which are marriage, divorce, and adoption. This goes with the laws of that country. In other words, what is valid here, what is valid here. Except, there are some exceptions to that. Unless the immigration law specifically provides excludability, like polygamy. like having 2 wives. Even if the Indian law permits that certain religious people to have more than 1 wife, immigration law doesn't permit. So you have to follow, when you are applying for any immigration benefits, you are looking at the immigration law. So this won't happen. You cannot do that. So going forward about the documentation, other documentation for which there is no bar. For example, a marriage. A person wants to go get married in India. There are 2 things they always want to see, both immigration and the consuls. Marriage must be bona fide, not a fraud marriage, not a paper marriage, real marriage. Marriage must be legally valid. Now, what I have seen in a lot of cases,
So you're talking about walking around the fire?
walking around the fire 5 times in Hindus when other religions have other religious ceremonies, what they do is they go to India, they want to jump the line. They go in and register the marriage would never took place. They put a date and they just register the marriage and they get a certificate. They think it's a marriage certificate from the court. It's not a court. It's the registrar of marriages who's only registering the ceremony. But the ceremony never took place. That has no meaning. It's not valid anymore. So we be very careful. We see on divorces, there is very limited manner in which the immigration service may accept a mutual divorce. For mutual divorces, like they go to court, buy a stamp paper, both parties sign, and they say, I have a divorce deed. I look at the divorce deed, I say it is a mutual divorce. For this, you have to prove that there is a long-standing custom and practice in that particular community. But I have experienced that most of the time the American consuls there, it's very hard for them to accept that. So the real thing, the right thing to do is to get a court order, a decree of divorce. Same thing on the adoptions. Adoptions in India, for example, Hindus can only adopt if they don't have a son or they don't have the daughter. Muslims and Christians are not permitted to adopt. They don't understand, they do the adoption. It's no longer valid. So it is very, very, very important that they must take into consideration our viewers when they are submitting in connection with an immigrant petition or visa application, any documents such as marriage, divorce.
Right. That they're bona fide
Or
documents.
bona fide documents and legal. Bona fide and legal.
And legal, according to the laws in that place.
I can tell you, every American consul in India, when the applicant goes, they got married and the wife goes for interview, they say, show me the pictures. There are a lot of pictures, but they don't see no pharaohs. He's doubtful. He say, where are the pharaohs? Oh, that photo did not work properly, didn't take an investigation. And they also doubt that this is one of those cases that they register, so they grill them. Tell me the truth. Tell me the truth. Right. Did you get married?
Because they're familiar with the cultural nuances, and that's their job, and which is why they're posted there, right? Yeah.
So they think that how will the council know? How will the council know? A lot of these things, now going beyond this subject of documents correction, a lot of things happen there that people apply, I don't know, going back to a little like fraud or misrepresentation. People give the proper papers, everything looks perfect, right? And all of a sudden consul says, do you have any relatives in US? He said, no. But isn't your father, Prakash Chandra Patel? How does he know? How does he know? Listen, those times were different. People got away with that 10, 15 years ago, 20 years ago. Today's date, they have access to all the records.
Well, the databases are much better. Yeah, the databases are much better now. And the databases, you don't know the databases read into each other. And the other thing is you don't know how the data is being entered into that database when it's going to become available to the government.
And when the people do things like that, the registration before the marriage, to one lie leads to another 10 more lies. Consul, they say, wherever the picture is taken, he's giving a wrong date. And
Inconsistencies in the case.
some people have done doctored, you won't believe it, doctored photos.
I believe it.
So what they do is they have a real marriage ceremony photos of somebody else. They take the necks out, put these clients on them. Photography today, they can do anything. And they are sitting and having a marriage, but those people are really not their parents or relatives, all right? As a matter of fact, I remember, this reminds me of in Hyderabad, I think in India, they had a studio which used to have 1 lakh rupees or 2 lakh rupees. They had the witnesses, they have the father, they have the mother, they have the decorations, everything. Just give them the money, you go there, everything is perfect, ready there. You sit there in the chairs and the performance is done.
It's unbelievable.
And the pictures and albums. So after 2, 3, 4 cases, one consular officer noticed that I've seen these photos earlier somewhere. So then they did the investigation, they found.
And witnesses were showing up for each wedding.
Same father, same mother. Right? So what we are trying to do is to tell our viewers that always stay out of fraud.
Take the high road. Take the high road.
Take the high road. And because later or sooner you get, let me tell you one, today is a day for, in this program, so interesting stories. And we're going to take one more interesting story, is where I remember many years ago, these other things some people do, fiancé. He filed a petition for actually wife, or fiancé petition. Actually she was unmarried at that time, but after filing a petition, went to India, he got married. And then the girl went to the consul to apply for a fiancé visa. The consul asked this girl, are you really sure that you are not married? He said, of course I'm not married, I'm only engaged. He said, very sure? He said, yes. So he said, okay, we'll let you know. And then the parents of the both husband and the wife, they were citizens staying outside. They said, we want to see the American consul. How dare, my son is a citizen, how dare they deny to his wife. The consul said, come in, sit down. And the consul says, tell us, sir, your daughter is married or he said, she's single. She never got married. You know what? He takes from his drawer a wedding picture and shows them, is this your son and is this your daughter? No, at that point, if they were smart, they would have said, sorry, sir, forgive or whatever. They said, no. They said, this somebody has doctored the photos, but the photos of my daughter and somebody else's body. Consul laughing, actually says, sir, you can go and we'll let you know. Obviously, they did a field investigation. They found they were married. They denied.
Right.
Denied, they applied for the waiver. Now, at that point, the waiver entered the New Delhi Immigration Office, and they had the whole record of what had happened. So they denied the waiver also. It took 2 years. I mean, ultimately I solved the problem. That's a good news.
Right.
That they went in on my advice and told the truth. The immigration officer came and I submitted a humanitarian thing that this guy was a military colonel and that kind of person. He was really, they shouldn't have done it.
No, take the high road.
Everybody in the family apologized something, and the kindness or the humanitarian thing got into the mind of the immigration officer, and on a motion to reconsider, she approved. And I must say that it took them maybe $15,000 to $20,000 in fees, plus about 3 years' time.
And that's an out of the ordinary case.
But what I'm saying, when people say, how will they know? How will they know? I have a perfect pictures. I got perfect, Kankotri, they call it.
Let's talk about secondary evidence, Michael. For example, if you don't have a birth certificate or you don't have one of those other documents, what would you use? How do you do that?
Basically, there's a rule that they have to have affidavits and some secondary evidence.
So other types of evidence that corroborates the facts. So you don't have to necessarily have the source document.
The birth certificate is not there. They need a letter from the municipal corporation or the registering authority certifying that we do not have the records.
Exactly. And what we do is we look to what's called the Foreign Affairs Manual, which everyone has access to. You can go online. It's at the U.S. Department of State website, travel.state.gov. You can take a look at that document. You can see the Foreign Affairs Manual tells you what source documents you can use.
I think it's time for a short break, and right after the break we will discuss some more interesting cases. But I hope that our viewers are getting a very good information and guidance that they should not commit any fraud or misrepresentation because the consequences are bad. After the break we are going to talk about the consequences and how some cases can be resolved. So stay tuned, we will be back. Welcome back. Before the break, we were talking about people that commit some frauds, misrepresentation, serious consequences. But let's talk about the solutions. In some cases, there is a waiver available. Waiver means in Hindi we say maafi nama or forgive me, forgiveness. The waiver provision, let me explain you briefly. Depending on the charge, if the charge is a fraud or misrepresentation and the person has qualifying relatives is a husband or a wife who is a US citizen or a green card holder, or a parent who is a US citizen or a green card holder, and they can show extreme hardship to that petitioner, not the beneficiary, not the applicant, the petitioner, then in the discretion of the immigration service, that can be waived. And once that is waived, then the person can get an immigrant visa. But it's not so easy, because Michael Fulwani said, okay, no problem, and David said, file just the 601 application form.
Well, I think this is also a good time to remind our viewers that in the past, before about 4 weeks ago, that the waiver applications were adjudicated abroad by the USCIS offices abroad, and that process now has changed, where what they've done is they've centralized the waiver application process in the United States, and the waivers are going to be sent to a lockbox where they're going to be adjudicated. So that's,
in other words, I agree with you. The previous provision was that if you apply for a waiver, you have to submit the application for a waiver with all the documents at the American consulate.
correct.
And the American consulate will
Forward it to the U.S.
Immigration Service in New Delhi. And that was the office that was approving or denying. And sometimes they were very busy, they will send to Bangkok or some other country for adjudication. And it took a long time, sometime a year, sometimes more than a year.
And the reason why it took so long is because, and Michael, we know because we had actually met with them when we were in India in March, April, and we spoke to them, and they told us about their investigatory procedures, and you know, that they go out and conduct investigations.
And I would say that this change is little helpful. Why? I'll tell you. In India, all the waiver applications are coming from India, Pakistan, Bangladesh, and those typical that kind of cases.
And the officers have in their mind a way that they see the world.
Exactly.
And it's interesting because now what's going to happen?
Now in the US, the immigration office is getting waiver applications from all over the world, including 75% from Mexico and authority. So they see this in that scenario, in the big picture.
So I feel the better way to describe it is they're going to be less discriminatory.
Yeah, and more favorable. In other words, it will be more favorable in adjudicating waiver application. One other thing also.
Yours is the positive spin, mine's the negative.
Correct. The other thing is that if the beneficiary, sometimes here, the person, beneficiary, the wife is here, husband is here, both, and there's a fraud or misrepresentation done, immigration service denies the petition, then they could file a waiver application here in the US, right? Or let us say a person who thinks that he cannot adjust the status. The law says he cannot adjust it. He came without a visa. There is no section 245I. So the only way to get his visa is, wife is a citizen. She files a petition. Petition is approved. He has to fly down to the American consulate to apply for the visa there. The consul denies the visa, charges with fraud, then the 601 has to be filed in India. So there's the other change that took place, is they are saying that kind of person who can do it is an advance waiver.
Remember that the advance waivers are not going to apply in the misrepresentation, right? They'll only apply to
9B.
212.
Exactly. So we're talking really, yeah, I'm glad you mentioned that. So the person is basically overstayed here illegally for more than a year, and there's a 10-year bar. 10-year bar. Now he has to fly down to India, apply for the visa. Consul says everything is fine. Sorry, your 10-year bar, and I cannot do anything. Apply for a waiver. So the waiver go the same way. Consulate, then go to Delhi, and then. So now they permitted that. They are saying that if the person is here due to unlawful presence, he doesn't have to go to consul to get a denial or a charge of 9B. The reason they were saying, we've not been charged with a 9B. How can you apply for a waiver? So now they made change in the policy, that if you know that you are subject to 9B, you can apply for advance waiver right here, get the waiver approved, and then you can go to India and apply for the visa, because he cannot adjust. So he'll have to get a visa from American consulate, India, Pakistan, Bangladesh, whatever the country is. So that's another important change. So
These are right, two very, very big important changes
Yeah.
to the law. Yeah.
These prosecutorial discretion memos, one after another, have been providing a different help in a way, and very welcome. So listen, it started with, remember, a number of different memorandums came in, and today we got the latest one that we talked about, the dreamers. Hopefully, they may go. This is a good policy he's doing. They are minutely examining where the Obama administration can administratively provide a relief that the law may require to be changed, or without changing the law, he can do it.
Right, and it's interesting because I think that a lot of this has to do with the political power play for the Latino vote. And just recently, I believe the statistics had come out that the Latinos are actually not the largest and growing population in the United States, actually Asians.
So yeah, we're running out of the time, and let us hope that more and more of these prosecutorial discretion memos come, and you guys can get more and more benefits, more and more ways to legalize your status, get the green cards and all that. Wish you best of luck to all of you. And David, you will join me in hoping that this will happen.
Absolutely. You know I do.
Okay, David, thank you very much for coming on the program again, and you have been very good with joining me in advising our viewers all this good information. And all the viewers, we thank you very, very much for watching the program on TV Asia.
त्वदीयपाद पंकजं नमामि देवी नर्मदे त्वदीयपाद पंकजं नमामि देवी नर्मदे।